first and foremost, I think it's really important to acknowledge, and I do now every time I talk about biodiversity, the fact that actually I think the human rights framework and human rights organizations have really neglected biodiversity as an area for very long. That's thankfully changing. And in the last 10 years, there's been, I think, a lot of good work in that space. But still, when we see climate and when we see biodiversity, we see a very different level of involvement and work that's gone in. And I hold up my hand and I say that because I did a lot of work for years investigating and talking about the impact of, for example, extractive industries as a human rights issue. And so we looked at a lot of issues of pollution and other issues linked to extractive industries, including on indigenous lands. And I must say that in that work, we rarely looked at biodiversity as a sort of distinct area and talked about its impact. Partly, I think it was because at that time, the legal framework was quite weak in terms of looking at biodiversity itself as a human rights issue. And then I think the other challenge, which I suspect you'll still encounter, is some of the sort of actual scientific and other evidence just on biodiversity itself. I mean, we did have it in certain cases, but when we did, it was always still talking about biodiversity, and naturally from a human rights perspective, in terms of its impact. So loss of biodiversity in terms of its impact on rights to food and others. But just to say, I think that has been a gap, but thankfully it's changing, but I think more work is needed on it. What I'm going to talk about today, though, is I think the general human rights principles around right to remedy and reparation, which I think are very powerful. And actually, we are seeing now in climate litigation, it is, in fact, increasingly becoming a strand that lawyers and courts are picking up and working off because it gives a lot of scope, I think, to look at harms, and because a lot of work has gone in for decades from human rights lawyers from different courts to try and think through, well, what is the nature of the harm that people are suffering and how do you remedy that? But this is, in a way, the core principle in all of international law, but particularly developed in human rights law, which is to say, when we say there are rights and there are responsibilities of states, there have to be remedies when those obligations are breached. Rights become fairly meaningless if you don't have a sort of a recourse when those rights or those obligations are breached. So in general terms, when we talk about the right to remedy, and please stop me at any point if I speak too quickly or if something isn't clear, there are sort of kind of three components that we talk about when we talk about right to remedy. The first is equal and effective access to justice. So in a way, that is the ability to access mechanisms which can give you what you need to remedy the harm you're suffering. The second part is what is called adequate, effective, and prompt reparation for harm suffered. And we'll go through that because I think that's what might offer the most potential for the kind of work you're doing. And then there is a kind of third linked element, but which is very, very important and very neglected, which is actually access to information about these kinds of mechanisms and the options that are available to you. So the right to remedy and reparation is widely recognized both in customary international law and in all human rights treaties. There is also a framework which was developed many years ago, but which is still very powerful. I think it needs a little bit of interpretation now and a bit more work in my view to develop it more for the climate and biodiversity context. But it's called the UN Basic Principles and Guidelines on the Right to Remedy and Reparations, which was developed by Theo van Boven, who was a UN expert who was asked to do this work. And that framework has given greater guidance on how you translate this framework and take it forward. So essentially building on what exists in international human rights law. Now, so when we look at, reparations, so when we say reparation, what does that mean? And I think here it's very important. There is a big effort constantly to reduce reparations to just, reparation is what you need to do to repair the harm caused to the person by the original violation, right? So essentially to try and the basic principle is to try and restore them as much as possible to the position that they were in before the harm occurred. There is actually some jurisprudence that's come out of different courts, particularly the Inter-American Court on Human Rights, which actually talks about transformative reparations. This concept has come up in the context of transitional justice, so particularly post-conflict and as countries are going through transition, which is an even more powerful idea. It's come up a lot in relation to gender and sexual violence, which says actually it may not be enough just to take the victim back to the position where they were before, where in fact, if there have been such structural issues around the issue, sometimes maybe you need to improve the situation that that person was in. But that's a kind of new and quite important idea. But when we talk about reparations, there are 5 recognized forms of reparation, and they're very, very important. And compensation is only one of them. And I think this is quite important for the work you do. So the first is restitution, which is aimed at establishing as much as possible the situation that existed before the violation occurred. So a classical example of that would be in an indigenous community has been moved off its traditional land. What restitution would require is that they are brought back onto that land, that basically they have access again to their traditional lands. And we've seen various judgments on this in different courts at the national and regional level in particular. There's the second form, which is the obvious one, is compensation, which is monetary payments for any economically accessible loss. But again, in the human rights context, a lot more work has gone into looking at, it's not just the economic, just sort of like straightforward damage. So for example, damage to fields, so which can be quantified and put in, but also basic principles talk about more than that, basically moral damage. They talk about the physical or mental harm that's caused to people, the lost opportunities. And there's some very, very powerful jurisprudence from the Inter-American Court, for example, talking about what this means. So I think you go beyond looking at material damage to the harm, and that's where some of the work now coming in is, for example, again, I think a lot of this is very powerful in the context of indigenous peoples and communities, is what is the harm to their culture when, for example, they have lost access or the land has been degraded or other harm has occurred to them. So how do you begin to, even from an economic perspective, how do you begin to quantify that beyond just the sort of material, you lost access to some trees and that meant you have, you had problems with access to medicine or whatever the case might be. The third element is rehabilitation, which is aimed at addressing the physical or psychological harm, and that can typically involve, in a standard context, is medical or psychological care. But in the work that we did in extractive industries, in fact, a lot of it was also things like rehabilitation of land, which has suffered pollution or other measures that would be required. So not just to people, but also to the environment. The fourth area is satisfaction, and that is essentially very, very important is, for example, a disclosure of the truth, an acknowledgement of the harm that is occurred, apology, acknowledgement, sanctions against the violators, etc. And it's really fascinating. I don't know what the experience you all have had in this area, but for me, for years working with communities and victims of human rights violations, it has been striking how important this dimension is to them and how neglected it is often when we talk. For a lot of communities, what's very, very important, in fact, in some cases, they've even told us even more than compensation, because sometimes they have the option of getting compensation, but no formal acknowledgement. And people have said, no, actually, for me, what's really important is an acknowledgement of what happened. It's a vindication of the experience of my harm and of having that publicly acknowledged in some way. And then that can be a very powerful process of also building forwards to, in fact, their involvement in defining also what is actually what they require in terms of the measures that should actually occur in terms of reparation. So guarantees of non-repetition is the other major aspect of this. It's quite meaningless, we find, if you say, well, there's been a violation and here's a remedy and reparation, but actually the violation itself, particularly on, say, environmental and other issues, is going to continue because actually nothing is really changing in the legal framework. And so a big part of this framework is cessation, which says you stop the conduct that resulted in the violation and you get guarantees of non-repetition. And this can, again, involve a variety of things. In certain cases, obviously, it's and it's in the context of a government, it's a sort of declaration, sometimes in court, of we will not, repeat this kind of behavior. Or it can be changes in laws and policies to ensure that there's prevention. And this is a big part of the human rights framework when it comes to reparation and remedy. It is looking at prevention. How do you prevent the same thing happening in the past? So, and how do you decide on the process of reparation? Again, a key principle in human rights law is taking into account the views of the victims and a recognition that they are of it. Isn't just technical expertise that should determine the process. Of course, that's important when we're looking at issues like, say, rehabilitation of land or the value of something, but the views of the victims, and they often have very strong guidance and input about what should happen. And of course, another idea is proportionality to the gravity of the violation and ensuring satisfaction for the harms that have occurred. So these are some of the kind of key aspects, and they have been very powerful in practice in terms of determining the kinds of remedies that courts have offered or that victims have asked for. There is, I will say, an important thing to note here, quite a significant difference, obviously, based on countries and how far they recognize different remedies and what's available in different systems, and also at the regional level. So, for example, the European Court is actually quite limited in the types of remedies it can offer people, and what we get from their jurisprudence is therefore very limited. The Inter-American and the African Court have much greater power, and we therefore see much stronger jurisprudence coming out from them, as well as their approach. I'm conscious of time, so I'll just give you some examples, for instance, of the kind of things that courts have looked at in the process. So, for example, the Inter-American Court, particularly in environmental issues and those involving indigenous peoples, for example, has required, removal of livestock, fences where, outsiders have come onto indigenous land, illegal logging, stopping that, conserving the surface and groundwater in indigenous territory. They have looked at issues such as, looking at, for example, even when nature reserves are being set up, for example, what has been the participation of indigenous peoples in relation to that, and ensuring that the protection measures that are looked at are actually compatible with what indigenous people want, rather than decided by some kind of notion of conservation, which doesn't look at revoking of mining concessions. And this is where, in fact, using that full measure of reparation, courts have gone much further in terms from beyond sort of pecuniary and harm and compensation to looking at, for example, community development funds to earmark to recover indigenous culture and right to cultural identity. So a lot of money is then put into actually how people can use that land or that money in the future. There are multiple examples of this, and I'm happy to go through some of them with you. But a lot of it is actually also then come in on changing legal systems in terms of titling and in terms of ensuring better protection, particularly from private actors who are often responsible through logging, hunting, mining, and other aspects in harming the land or the rights of indigenous people to enjoy those areas. And another last thing I would say in this is, I think and I think you all will be more familiar with this than I am even, is to say, basically, we know that the actual litigation linked to biodiversity and human rights is still nascent, but I would say it's important to say it is growing, and we are beginning to see a lot of interesting, again, case law that's coming out that's acknowledging that aspect. Within the right to a healthy environment in particular, but also linking to other rights. So I think, again, you'll be familiar most likely with a recent decision of the Constitutional Court of Colombia, for example, which is looking at basically the protection of biodiversity as a key ingredient of the right to a healthy environment. There's been sort of similar cases coming out of Costa Rica. And again, coming back to the Inter-American Court, there's a 2020 decision, Oaxaca Honhat versus Argentina, where explicitly, in fact, the court did conclude that the right to healthy environment was violated by the degradation of forests and biodiversity. So I think there is a lot of scope here, but I would say a couple of just concluding remarks on this. One of the challenges we are seeing in this field is that there is still, unlike in climate, and I know you all are changing that, there is perhaps less strategic litigation which is being developed, which is explicitly developing or focusing on the harm to biodiversity as a component. So often it's still a secondary or I wouldn't say incidental, but a secondary sort of thing that is developed in the case law. And we're not seeing that still yet. And I think your work, as I said, may be changing that. But one of the challenges is to not see that explicit link being pulled out, and also more work just actually developing that legal framework. The UN Special Rapporteur on Environment has done reports looking at biodiversity and the link with human rights, but it's still an area where more work can happen. The second aspect, I would say, is as you know, in the climate space, it's been, the litigation really got boosted by the work of the Carbon Majors database, which could look at in terms of causation and attribution responsibility. So here I am talking a little bit about things that are multi-jurisdictional. So particularly when we're looking at the responsibility of various states for what is happening in a country or what people are experiencing. So that kind of both scientific evidence as well as notions of things like, so fair share in the climate context has really helped, as well as the data on emissions. And on biodiversity, I think there's still a little bit of a struggle in terms of being able to get the level of evidence that is required sometimes to bring it to the courts. But I'll stop there and just more keen to hear your thoughts and discussions and on the kinds of issues you're encountering.
Thank you, Meghna, for a very interesting insight from human rights litigation. It's interesting to see that we've seen in countries nowadays, there is an effort to also bring biodiversity and human rights together. But so long what we have seen is that they try to invoke human rights clause in a framework of environmental litigation. So we don't really see this the human rights framework along with its remedies being used, because the framework being used is environmental litigation. We've seen cases in Philippines and Indonesia that do that. They did mention that this is a violation of human rights, but because the whole box is on environment, the remedies is also limited just on what the environmental law provided. So I will open the floor if you have several questions, but then let's start with the floor first. If any of you have further questions. Okay, Stroyan, please.
Hi, Meghna. Thanks for the very interesting discussion. I'm an assistant editor for transnational environmental law, and we are seeing a lot of articles recently and a lot of interest on rights of nature. So I'm wondering if you have any kind of thoughts on that, or if there's much discussion in the human rights academic scholarship as there is in the environmental law scholarship as well. And also, just as more as a comment than a question, I was thinking how, like, the fourfold framework which you described, maybe with the exception of satisfaction, is also like super connected to how we think about compensation for biodiversity. I'm sure this kind of filtered through everyone's mind who was listening, but sort of restitution and compensation, and then even if you're talking about psychological harm, we don't necessarily think about psychological harm for nature itself, but I guess this is one of the things that Rika and Jacob, who's not here today, but they're all sort of trying to incorporate all of this into the calculus for compensation for damages, which is kind of thinking about the psychological impact on humans that results from destruction of nature. Yeah. Anyway, but thank you for that. And yeah, mainly I was just curious about your thoughts on rights of nature.
Thanks very much, Sharon. I didn't touch rights of nature, partly because I was hoping it would come up in the discussion, but obviously starting more from the kind of the human rights discourse, because obviously the right to nature is sort of much more about nature being recognized independently as an entity which has its rights and therefore not being dependent on the relationship with humans. I think there is a lot of discussion on this, and I don't know if you've seen this recent report by Susie Talbot, who is a human rights lawyer, looking at some of the legal frameworks and developments, particularly looking at some of the examples coming out of New Zealand and others. I mean, I think it is very important. It's a trend that is happening. You know, we are seeing a recognition in different jurisdictions and courts of it. We're also seeing it, just to say, outside of litigation. I'm aware of, I was recently hearing work by campaigners who are talking about nature as a stakeholder on corporate boards. So faith in nature, I can send a link, is a company, for example, that has nature as a stakeholder on its board, and that's an attempt that groups coming more from a kind of corporate law background and others are trying to push for. I think it's important, and I think it's very useful, but I must say I struggle a little bit with the idea that ultimately who speaks for nature, because I think it's an interesting concept, but ultimately someone's weighing in on the sort of interests of nature, and coming in with that. So there are, in fact, parallels to work that's happened with children. And that is the analogy that is being discussed and looked at. So when we looked at the best interests of the child, and we had guardians who would look at that. So I think it's very important, and I think it's useful, but I do worry a little bit about the potential clashes, therefore, if we are going to be seeing areas where I think we've seen that a lot. I think we know that in the whole conservation biodiversity space, there is a lot of bad history of conservation approaches which were quite colonialist, which were quite exclusionary of the interests of people, particularly people who have traditionally lived on that land and created this kind of false dichotomy between nature and humans. So I think it is an interesting approach, but I am kind of concerned about seeing how some of that tension is managed, and the risk of sort of seeing initiatives which are going to be about protecting the interests of nature, but might be therefore quite exclusionary of people who depend on that nature. So I think it is important. On the aspects that you said, Sean, I'm not at all surprised, and it's great to hear that the work is looking more broadly. I would just sort of say, I think one of the dangers of, one of the values, I think, of looking at the other forms of reparation is the ability to look at measures which go beyond compensation. Because at the end of the day, compensation is very important, but it's a limited tool. It may not offer you the full range of support that you need in order to get certain changes, right? So I think the value of the human rights framework is that ability to actually really challenge policy and to get other kinds of measures put in place, which, as I said, will also have a preventative aspect beyond just sort of remediation of the harm that occurs. But of course, that's a strategic choice and one that people need to look at in different contexts. But I think this has been, when we look at the litigation that's happened in this space, what's very powerful, I mean, implementation of judgments is a problem across all of the areas. So parking that for a minute. But what's very powerful is where the courts are talking about, really therefore then asking for a policy review of what is happening to protect biodiversity. What is the impact assessment around certain kinds of economic activity which are being allowed, etc. So that is, I think, the potential, but that may not be, of course, a good fit strategically for what people are trying to advance.
I would like to double down on the choice of remedies that's been discussed. I think we have this discussion with Valerie earlier, that in environment, we also want a full recovery of restoration of nature, and EU directive provide that kind of remedies. But then in practice, when the restoration is deemed not possible by the government, then they will change it into monetary compensation, because it's just not possible to return to the, if I may use your word, to return to the original situation. And we don't want it to be taken like lightly. You just like can replace restitution with compensation, but is there any such thing that happen in human rights litigation? Like, because the main goal is to heal, to make the public whole again, but sometimes it's just not practical to do so, and then people are trying to look other way, like to other remedies to compensate this gap between what you can do.
Absolutely. So I think, I mean, this is it's a Rick, I mean, it's a standard challenge, and I think most legal frameworks, Valerie, it'll be interesting to hear your views on this, recognize that, right? So in fact, it was built into, in fact, some of the environmental treaties. In human rights terms, it's also recognized that, you know, often well, it depends. For certain harms, compensation is required, right? Where you've lost, if you're a community that's lost, you know, access, your farms are now completely inhabitable, you also need compensation just to be able to live, right? So there are different needs for what it's doing for you. But yes, that compensation should not replace that emphasis on restitution. But this is where I think, to me, one of the powerful things I found in my career working with communities of the human rights framework is it brings them into that discussion. You know, we don't want an expert to say, yes, you may not be able to go back to exactly what you had before, but communities often have strong ideas of how repair can happen, of what they think is required. In certain cases, courts have looked at actually replacement land, but that's a more complex area. So, and then there's a whole framework of if you're going to move people, because let's say an area has become completely unlivable, for lack of a better word, or of course, you know, sometimes when it's moved to different hands and it's no longer possible to get it back. But I think that focus on, yes, it may not go back exactly to what it was before, but what can be done from people's aspect to allow them to live, or for the importance of that particular, you know, for example, yeah, we know forests can't just be replaced with more trees, but I think that emphasis on what is it that would help you in that context, what would enable you to go back as far as possible, is one important. But second, as I said, that preventative aspect of it, because one of the dangers of compensation-based work we see is that it's then based on the level of compensation, it's quite easy for companies to continue. And there really isn't a sort of preventative or sanctioning element of the remedy. And if that focus is kept, and, you know, I think, I mean, I'm sure with you all, it's a very live debate. One thing I'm looking at the moment is offsets, and the whole promotion of sort of biodiversity offsets as a way to go forward. And to me, that's fundamentally challenging, because it is just sort of trying to say that what should be a backup option is now being really promoted more and more as a kind of front runner.
Right.
So we're losing that focus on prevention.
Yeah. Valerie, do you have any comment on that? I remember we have this discussion last year. We thought EU directive is a good example on how to pursue restoration as primary remedies, but eventually in the application, if you can't do that, then you just replace it with monetary compensation.
Yeah, thank you very much, Rika. That Meghna, that was fascinating. Thank you very much. It adds a whole. I just tend to look at non-human rights, right? Environmental rights. So it's very interesting to put it in perspective with the human rights. Yeah, this thing about compensation, etc. And with this EU directive, the Environmental Liability Directive, says you never, okay, sorry, not never, but you always do compensation in kind. And you can under the directive, because three kinds of, we're just talking water and biodiversity, not land. But looking for those two, primary remediation is efforts after damage to it to get it back to the baseline. If you can't do that, then you look to, you do complementary remediation, which can include increasing nature at an alternative site. And because you can do that, and then compensatory is to compensate for the loss of biodiversity from the damage until it's full restoration. But because you can do complementary, you never get into a situation where you apply monetary compensation. And often monetary compensation, say in, for example, Lithuania, Latvia, will go to the state, and it may be used for something completely different, because it just tends to go into the general fund. Now, what we've found, and I'm doing training on this directive right now. We were in Athens a couple of weeks ago. Now we're going to be in, where are we going next? Bucharest in Romania, and then Latvia in February. What is interesting, not many member states, okay, this directive is not being implemented properly in most member states. There aren't that many cases on it. But what I didn't understand is why, I can understand why operators don't want complementary compensatory remediation, because it's going to cost them a lot more money. I couldn't understand why competent authorities didn't want it. And then I started looking into it further last week. And it's this equivalency analysis, right? Where you then have to come up with what do you do that's equivalent to the damage that you've caused. And what the Environmental Liability Directive says is, first, you go to resources or services to services. That's either the damaged water or biodiversity or the services rendered by them. And only if those two don't work, then you go to monetary. When you're trying to put a value on something. And we all know, Rika, Jacob, and everybody, how difficult it is to try to put a monetary value on biodiversity. But what I didn't understand till about last week after we did this training session is how difficult it is to do this resource to resource and services to services. When you start looking at the equivalency analysis you're doing, it is horrendously complicated. So I can see why competent authorities are simply not doing it. So I've gone from saying I don't understand why they're not doing to say, yeah, I understand very well why they're not doing it. It is, for example, there was a case in England, the only real case where I've actually got the papers of how they did this equivalency analysis, and they actually ended up doing it on Excel spreadsheets. But it was damage to a river, and it damaged, they said the main damage was to fish in the river. So it was damaging the right of this angling society, for example, to fish in the river. And they took the days lost by the anglers over about a 5-year period and the amount of fish that it took, they were restocking to get back to where they started. And it's horrendously complicated. So I guess I don't really have a question as such as, as really a comment, how difficult it is to do that. I mean, when you're looking at human rights, do you look at like equivalency analysis, for example, or is that just doesn't count? And also in the second, very, very short one, why is it that the Southern Hemisphere has more rights to nature than the Northern Hemisphere? I've never really understood that. Thank you.
Thanks, Valerie. That's really interesting, and I'd love to hear more about that. I think this issue that you're raising, it is very complex. I would just sort of say my innate reaction, therefore, is to come back and say, but should the approach, therefore, not just be precautionary? Because I think we found that the precautionary principle allows us to get past some of this, without having this complete sort of thing to say, actually, we should be erring far more on the side of protection, knowing that there are gaps in information, rather than having to do this. So yes, I mean, it's not exactly equivalency, but there is very similar stuff that would come up in the human rights context. For example, if you said for, the work that I was involved in Amnesty, looking at pollution from Shell and other companies in the Niger Delta, right? So if you're saying, well, okay, there's oil pollution, damage to, damage to various water bodies, damage to fish, etc. It often becomes, again, you sort of get stuck with what is the loss to people exactly. So it's like basically if they were fishing and then, okay, here's the kind of quantification of that fishing, etc. But what it's not doing, unfortunately, and this is the problem, and this is where the gap of information is, well, actually, the damage is not just what they're losing. It's also the future implications for that ecosystem. that is much, much harder to capture. So you're stuck then with this kind of very basic, essentially sort of calculation of harm, whereas the bit that we are missing in this is what is actually the overall harm to that ecosystem, and how do you replace? I mean, can that be replaced at all? As I said, so then you get into, yes, so compensation alternatives. So would, there'd be often discussions on, okay, if this community can't farm anymore, is something being offered to them in terms of employment, etc. But that aspect of actually just the loss of the ecosystem and what that means overall for other people is not being properly factored in the human rights analysis. I think so. I think that is what you're saying is very, very important. But I think what we might want to switch on that is the approach. Is my innate instinct is that actually instead of being caught in this, I think we should say the balance of the fact that we don't have the information on the harm. We need to be very strongly arguing that actually the responsibility should shift to the operator to show how whatever they are doing is not going to result in harms that can't be remediated in the future, right? I think it's actually a little bit inverse at the moment to me. If you're coming into something and you're coming up with an activity that's going to cause harm, why are the people who are going to be harmed by it having to show, although it should be on the operators to really assess and show. And in the context of biodiversity, I think we should be going now to a much, much higher standard, particularly for more fragile ecosystems than we have been so far. But that's a shift in approach and maybe a bit idealistic, possibly. But I think there's a good argument to be made in human rights to do that.
Well, that is I never have thought of that before, actually. That's an excellent argument. But how would you do it? Would you, for example, you can put it in a permit to do something, maybe, but everybody cannot have a permit. For example, if you've got farmers, for example, you can't say that every farmer in the country is going to have a permit to farm. So it's, I think it's a really excellent approach. I'm just wondering how it would work.
I think it would have to be, so I think, like what is well recognized at the moment is it's where it's scale. I think obviously one, so scale is important. So where the scale of an operation, I think it's a bit easier, large scale operations, therefore larger risk of harm. It's the nature of the risk. So I think particularly, and I think this is where we need the work of the scientists to, there is work on that, but to sort of make it more localized to say, well, these are particularly sensitive ecosystems, or which are more fragile, or harm to these ecosystems is going to have more ramifications. I think then you can be looking at a higher standard. So I think there are a series of criteria that we could use, and one of those in my mind we should stop. I'm always hearing on biodiversity we don't have the knowledge, but as I said at this point, I'd be arguing very strongly for a precautionary approach to say, because we don't know, we might want to assume the harm is going to be worse, rather than discount, which seems to be the current approach, to say, therefore, we don't know, so therefore the harm is something that could be fixed in the future. But yeah, I think there's a series of things that could be used. I think there's a lot of, again, that is a lot of the work, as you know, Valerie, around the sort of example, the attempts right now on deforestation to get the EU directive are a little bit about capturing those. So these are very traditional approaches that we've used with corporate activity and economic activity. But as I said, I think the biodiversity part of it has just not been developed strongly enough.
And
No,
for the
thank you.
second question, Valerie have a question about why right of nature are more prominent in Southern.
Oh, yes, I'm so sorry, I forgot about that. I mean, I think it's, well, I think it partly comes down to, in my mind, I'm not an expert in this particular area, but to me, some of the hypotheses for this would be, first of all, the right to environment, the right to a healthy environment is more recognized in constitutions in Global South countries. So that is one, or even the interpretation of it. So for example, the Supreme Court of India has read in the right to a healthy environment into the right to life. So there's a more expansive jurisprudence. I'm afraid this was my years of work on economic, social, cultural rights. It partly also just has to do with the hostility in Europe to economic, social, and cultural rights. The legal systems are very, very poor at recognizing and protecting economic, social, cultural rights as enforceable rights. So we see much less, and most of these issues at the end of the day intersect with economic, social, cultural rights, food, health, water, even healthy environment in some ways has come out of the right to health originally, actually, in terms of its genesis. So I think, unfortunately, we still see I call it I make myself very popular in legal circles, and I say Europe and North America are quite backward when it comes to economic, social, cultural rights compared to the rest of the world. But that is the hang-up, therefore, that we then have to navigate.
Really interesting. And I never put two and two together because, for example, in the UK, environmental law came out of health law, human health law, and I never made that connection. So thank you.
Thank you. Oh, okay. Lena have a question.
Yeah, sorry, I cannot find the hand.
Okay.
I have two questions, and I'm not a practitioner, so my question might be naive. One is a clarificatory one. Like you mentioned 6 points, and from my perspective, all they seem very important. So are they all used in combination? If they are not, then why not? And my second question was about, I've been working a little bit, but from the theoretical side or philosophical side on climate change, biodiversity, on rights of nature, human rights. And often it seems to me that it's come up to conflicting rights, like the rights of development with the rights to a healthy environment, or at different scales, you have always this conflict of rights. And so I was wondering how in your practice, how do you approach these conflicting rights, and how is there like a prioritization between different forms of rights, or is there anything, or how do you deal with this situation? Thank you. And it was very interesting, of course.
Glad to hear that. Thank you. So Lena, I would say, is it Lena? I just want to make sure.
Yeah, Lena, it's fine. Yeah, thank you.
No problem. So Elena, on the different forms of the 5 forms of reparations, actually there are, and then there's is basically should always be. I mean, as I said, there's a slight problem of the court or the body that you're going to, what they can actually offer. So not all systems have the ability to give orders, remedies in terms of all 5. But from a human rights law perspective, when we look at remedy and reparation, we should always be looking at all 5 forms together. And then, as I said, it's a variety of factors that should come in. Obviously, the nature of the harm, the views of the victim, proportionality to the gravity of the violation, and just satisfaction. So it's that combination that should be looking at, therefore, but all 5 should be in play in any given situation rather than just one. And as I said, it's very unfortunate, but especially in the West, when you talk about reparation, it's only compensation. We can see that right now if you're following the debate on the Commonwealth, and the whole discussion on reparation is just always reduced to, well, why should we pay compensation for what was done in the past? And you're like, that is not the point of talking about reparation. You could even start off genuinely with an acknowledgement and an apology, and maybe that would make the conversation very important, because I think a big part of this, which is to stop the problem from occurring again. If you don't acknowledge, and this is why the reparation framework is so, if you don't acknowledge what's causing the issue, the chances are it's going to keep happening over and over again. And I think it's that aspect of it, but that's one of my favorite ranting points. The second thing that you said, so I think it comes down to how we look at the rights. So genuinely, I found that the issue of conflict of rights is often, there are instances where we have to deal with a balance between different rights. So that's how I think of it. I don't think this is a conflict. I think of it as how do you balance? Because ultimately, in any situation we're looking in, there is a balance of different interests. And that's a reality, right? But I think it is how we've always tried in the work that we've done in the different organizations I've worked in, to try and look at something that is going to be, as far as possible, actually, ideally you want to try and, there are contexts in which you can't. So the pandemic is a great example, obviously, where you've got the right to health imperative is forcing a restriction on other rights. But still, often the question is, there are measures that you can use that could be, that could help alleviate the impact, for example, on right to work or social security or food or whatever it might be, the case might be. A lot of this, I think, comes down now to me is what we understand by the right to development and the model of growth. So actually, in the work that I'm currently doing around reparations, that I'm exploring, I should say, rather than doing, because it's an initial stage, I think, to me, it's really interesting when we look at biodiversity laws, how much of this is linked to actually a model of development, which I would not say is a right to development, but a model of development that has been pursued, particularly by global north countries. And then that has been then prescribed in law in, for example, the Agreement on Agriculture and the impact of agricultural subsidies, for example, in terms of driving certain monocultures and other practices in other countries. So I think actually if we're serious about really a rights perspective there, I think we actually more need to question the economic model. But that is something I would just say, frankly, the human rights community or most even the environmental community, that's changing. We've been reluctant to get into looking at models. We've been much more comfortable looking at a procedural level or a technical level rather than questioning the model itself. But actually, I think now where we are, we have to be saying, well, we need to look at the actual model and what is then really going to be compatible with both the rights of nature and human rights. The answer might lie in actually questioning and changing the economic model. But that also then brings up, from a human rights perspective, what is now the most neglected area, which is international cooperation and assistance. So if we're making changes in one country, how is the impact on another country going to be managed? And the climate finance discussion is one, biodiversity finance is even weaker, but it's that kind of more macroeconomic, political economy questions and how far the legal framework and actors are willing to look at that.
Okay, thank you. Can I just, does it mean that, for instance, from a theoretical perspective, like the right to food of some communities might conflict with the right of nature of some species? Right. And or we have even the easily like I don't know, like, I didn't prepare these words in English in my head. The sheep in the Alps on the wolf, on the conflict that comes up every 2 months about the wolf eating the sheep, and then you have this conflict again, right, from interest, but can also be translated in conflicts of rights. I'm from ethics and philosophy environmental, and it's often popping up in discussion that there are conflicts between rights. But is it actually something that doesn't pop up that much in actual litigation practice?
I would say I'm not myself a very active litigator. I used to litigate years ago, but I've been more involved in sort of like more legal work, so feeding into litigation, but not myself directly litigating. It does come up in litigation. Very often we do see in courts come at, because often then other people bring up this question. But I would say perhaps, first of all, there's an understanding of what is the right to food, because the right to food is much more about what people actually need. It's far more supportive of smallholder models. It's about what people actually need to feed themselves. I don't know that much about I get the question with some of this is obviously, first, I think it needs an unpacking of what is actually practice and what is required for rights, right? So I won't go into the sheep because I don't know about it. But for example, there are a lot of cases where, yes, there is the question is, I would say that there is a conflict coming up because of certain practices, grazing practices or others. What we have to unpack is, where is that coming from? And is that actually really linked to the interest of smallholders and other people? Or is there, again, a sort of business interest and model there, which is driving that? So sometimes I think it is you sort of get into a zero-sum game instead of asking, are there alternatives here, which could actually be more protective of smallholders, potentially other farmers, when we begin to look at EU agricultural subsidies, I hate to say, and then, the interests also of the nature and wildlife. But that's where, I could say, coming from India, to me, the bigger challenge was the way we know now, we have overwhelming evidence that the conservation model was the problem. Actually, indigenous communities had far better knowledge about how to maintain and look after nature and biodiversity. And that was eroded, and it was put away because it was seen as inferior because of colonial notions. And then that conflict has actually been generated more by governmental practice rather than actually some innate conflict between people and nature. But that's complex now where things are. But for me, from a human rights perspective, going beyond. So I think often the human rights framework is being used just to look at the actual effects of something, but the real power of the human rights framework to me is to look at the causes. It's far more complex an analysis, but if we do that, then I think we get past the more superficial notion of conflicts.
Thank you. I love this.
Yeah, it's interesting because Laina mentioned about the competing, the interest of right that seems to be contradict with each other, and it's interesting how you frame it as not a competing things, but to find a balance, because we also have this discussion on biodiversity and climate change. We have litigation where the two different interests of nature come up, especially in renewable energy development. Like you have a lot of conflict on renewable energy development with the local people and also with the species conservation. And since Adrian will convene a workshop next month on the study on renewable energy project in Japan, Germany, and France, if I'm not mistaken. Adrian, do you want to?
Yes, thank you. Thank you very much, Lika, for mentioning the workshop, and thank you very much for your presentation. It was very, very interesting. And thank you, Lika, because I had just one question before the time is closing. So I have one question about the acknowledgement you mentioned, and I would like to know if there is any strategic aspect related to this fact of acknowledging in courts, maybe for future litigation, or maybe in terms of the relationship between judiciary, legislative, and administrative branches, like to obtain, legal change or legal change, or is it purely related to symbolic justice, which is also extremely important, as you mentioned it, for plaintiffs, the recognition is extremely important. But I would like to know if there is a difference from a legal point of view.
Thanks, Adrian. So you mean the acknowledgement of wrongdoing, essentially?
Yes, exactly.
Yes.
The fact to acknowledge it and to apologize, as you mentioned, it's very important, and yeah.
Yeah, no, it is very important, and it has a lot of legal implication. So this is why you'll often find that there are, this is fundamentally the difference in approach, right? So why, in fact, governments will often want to settle cases, because when they settle the case, they don't have to make this acknowledgement publicly. So you can settle and just give a compensation, and then the matter goes away without a formal acknowledgement of wrongdoing. Because obviously, once there is a formal acknowledgement of wrongdoing, and as I said, combined with the guarantee of cessation and non-repetition, that particularly at the level of a policy. So obviously, if the conduct was, let's say you didn't follow your own laws, and because of, say, corruption or something, you've acted then and given a concession to somebody or whatever it might have been. I mean, in that context, there would be ramifications for the person, but perhaps less for the state from a policy context. But where there's an acknowledgement the policy itself is wrong, or there are gaps in law, then corrective action following that acknowledgement, there's a lot of implications, including for others who are affected. So first of all, for the state and the pressure that then comes on the state to then take corrective action, which the court may require, but in any case is opened up once you've done that, but also to other plaintiffs. Because once you've acknowledged something is wrong and you're not fixing it, then the others have an open door to come in and do that, which is why often governments try and find ways to not acknowledge the wrongdoing, essentially.
Okay, so it's very clear. Thank you very much.
That's an interesting point, because we have our first human rights litigation related to environment in Indonesia about pollution in Jakarta. So the plaintiff evoked that the government has violated human right to healthy environment because they have failed to implement several policies to provide the clean air. The case is actually won by the plaintiff, so the court grant the plaintiff demand, but the court refused to acknowledge that this is a human right violation. So it's interesting when you say that acknowledgement actually bring legal implication. I never seen it that way. We are all confused for this decision because we want, but it doesn't really feel like we want. And like it's just a small remedy that they ask that the court to declare government has violated their human rights. But then that's the only one remedies that the court doesn't give.
because of its implications, because it's then because Indonesia has the enforcement is weak, but the legal system is strong. And once they have that acknowledgement in court, then it has a lot of ramifications for it. But this is also where, I mean, unfortunately, a big issue that I'm sure you're encountering all the time is judicial attitudes. Because just because something is in the law doesn't mean that the courts actually fully believe in it. They might find it quite alien to see certain issues, or they may have their own attitudinal problems when it comes to that. But yeah, I mean, overall, I would say that I think I think it's the work y'all are doing, the little bit that I've heard about from Jacob and I'm hearing from you all, it's really interesting. But I think there's a lot of potential here to be going deeper to using the human rights framework. And as I said, what's interesting actually in climate litigation is what I'm hearing from climate litigators, because I'm doing quite a lot of work on climate at the moment, is actually in the end, they're using the human rights framework a lot more now. And that's where they're getting more victories, including because I think, as I said, it stops the issue of just being technical and you can see the impact. And then that human story of the impact is often very powerful, we know, not just for campaigning, but also with judges at the end of the day.
Right. Thank you, Meghna, for your time. It's almost 1 hour. I hope we have more, but then we decide to make it short and exciting for 1 hour. Before closing the session, I would like to give Adrienne a time to promote her workshop next month, because it will be open as well, right, to the BELS member.
Yes, exactly. It's open to everybody interested in the subject. It's about energy transition. So it's a critical analysis of energy transition concept through meanings, governance, and litigation. And we focus on 3 countries, which are France, Germany, and Japan. And maybe we can diffuse the program through BELS mailing list. I don't know if it's okay for you.
Yeah.
If the program, and it's online. It's in Japan, in Tokyo, but it's also possible to attend the workshop online. So anybody interested can just send me an email and I will give the Zoom link. So maybe Lika I will diffuse it through the mailing list. Yeah, okay, thank you. Give me the green light.
Maybe the human rights things will come up, because it's come out a lot in renewable energy projects.
Yes.
And you have litigation part on it, right?
Exactly, litigation and the strategic litigation used exactly in energy transition. And we are going to talk about, of course, Fukushima, but also in Germany, renewable energy and especially wind farm related litigation. Yeah. And I don't think we are going to talk this time about biodiversity. But maybe for the next event we will organize, we will touch on this specific subject, or at least I hope.
Okay. Thank you, Adrienne. Thank you, Meghna. Thank you, everyone. I hope to see you in the next 2 months. If you want to present or have some suggestion on the topic that we can discuss in the next BELS bi-monthly meeting, please let me know.
Thank
you very much.
Thanks, Rika.
Thank you so much.
Thank you.
Bye.
Bye.